Welcome to meeting number 93 of the House of Commons Standing Committee on Public Safety and National Security. Today's meeting is taking place in a hybrid format pursuant to the standing orders. Members are attending in person in the room and remotely using the Zoom application. I would like to make a few comments for the benefit of witnesses and members. Please wait until I recognize you by name before speaking. To prevent disruptive audio feedback incidents during our meeting, we kindly ask that all participants keep their earpieces away from any microphone. Audio feedback incidents can seriously injure interpreters and disrupt our proceedings. A reminder that all comments should be addressed through the chair. Pursuant the order of reference on Monday, March 27, 2023, the committee resumes its study of Bill C-26, an act respecting cybersecurity, amending the Telecommunications Act, and making consequential amendments to other acts. I would like now to welcome our witnesses for the first panel. BlackBerry, John DeBoer, Senior Director, Government Affairs and Public Policy, Canada. Canadian Cyber Threat Exchange, Jennifer Quaid, Executive Director. Electricity Canada, Francis Bradley, President and Chief Executive Officer. Up to 5 minutes will be given for opening remarks, after which we will proceed with rounds of questions. Welcome to all of you. I now invite Mr. DeBoer to make an opening statement, please.
Thank you, Mr. Chair. On behalf of BlackBerry, I am delighted to speak with committee members today. For over 35 years, BlackBerry has invented and built trusted solutions to give people, governments, and businesses the ability to stay secure and productive. Today, we are a leader in cybersecurity, software, and services. We protect more than 500 million systems worldwide. Our customers include all G7 governments, NATO, 45 of the Fortune 100 companies, 9 of the top 10 global banks, and numerous critical infrastructure entities. Critical infrastructure is a prime target for cybercriminals and state-sponsored actors. At BlackBerry, we know this firsthand. Between September and December of 2023, we stopped more than 5.2 million cyber attacks. 62% of those targeted critical infrastructure. Just yesterday, Canada's Centre for Cybersecurity, along with Five Eyes partners, issued an advisory confirming that a PRC state-sponsored cyber actor had compromised entities across multiple critical infrastructure sectors in the United States, including communications, energy, transportation, and water and wastewater infrastructure. The director of the U.S. Cybersecurity Infrastructure Security Agency fears that this is, quote, likely the tip of the iceberg, unquote. Canada's Cyber Centre assesses that, quote, should U.S. infrastructure be disrupted, Canada would likely be affected due to cross-border integration, unquote. In addition to delivering essential services, critical infrastructure entities house large amounts of sensitive information, including intellectual property, technical designs, and personal information that are attractive targets for cyber threat actors. Currently, apart from PIPEDA-related obligations, Canada has no legislation in place to govern, much less obligate, critical infrastructure entities to report, prepare for, and prevent cybersecurity incidents. The Critical Cyber Systems Protection Act will help drive necessary investment to improve cyber resilience and help ensure that critical infrastructure entities can operate through disruption and recover rapidly. Stepping back to a larger comparative picture, Canada is falling behind our G7 peers in cybersecurity. U.S. and European governments have already taken regulatory measures that raise the bar on critical infrastructure cybersecurity. In March of 2022, President Biden signed into law the Cyber Incident Reporting for Critical Infrastructure Act, requiring covered critical infrastructure entities to report cybersecurity incidents to government within 72 hours and ransomware payments within 24 hours. In October of 2022, the European Union approved legislation requiring operators of essential services to implement baseline cybersecurity measures and notify national authorities of serious cybersecurity events within 72 hours. Canada is currently out of step with our closest allies on cybersecurity and this legislation will help close the gap. Cyber incident reporting will help government and private sector entities quickly share relevant information, warn and protect other potential victims, and rapidly deploy resources and assistance to contain damage from cyber incidents. As the committee considers this legislation, BlackBerry would like to offer 3 recommendations to strengthen the law. First, harmonize cyber incident reporting requirements with our key allies, notably the United States. Doing so will help minimize unnecessary burden on reporting entities and help ensure that the resources of entities facing an incident are dedicated to mitigating the effects of cyber incidents. Second, provide guarantees that cyber information reported by the cover entities are protected from liability based on the information they report. And third, ensure that entities covered by the cyber incident reporting requirements are not punished by punitive measures for good faith efforts to comply with the law. In conclusion, this law will help close the gap in our country's ability to prevent cyber attacks, improve situational awareness, foster rapid and effective response, and help create a culture of proactive, prevention-first cybersecurity at scale. BlackBerry stands ready to work with this committee to strengthen Canada's cyber resilience. Thank you.
Thank you, Mr. DeBorme. Mrs. Quaid, if you'd like to be next, please.
Thank you. Good morning, Mr. Chair, and thank you all. I have the honour of being here today representing the Canadian Cyber Threat Exchange, an organization created by Canadian companies to provide a safe environment for members to share cyber threat information and collaborate by sharing best practices and ideas. The goal is to build cyber resilience, to create a stronger economic environment for all. With 170 members representing 15 sectors and more than 1.5 million employees, our members are actively sharing cyber threat information to help build awareness and resilience in others, to prevent breaches and the corresponding need to report. Many of our members represent the critical infrastructure sectors impacted by this legislation, while others make up their supply chain, many of whom are small and medium businesses, like so much of the Canadian economy. I applaud the government for focusing their attention on creating legislation that will help to strengthen Canada's critical infrastructure sector. I also believe that with a few small modifications, there is an opportunity with this legislation to do more, to support resilience amongst Canadian businesses, and to strengthen the Canadian economy beyond the confines of the 6 critical infrastructure sectors referenced. Others have spoken eloquently about privacy issues and about the real risks of attributing liability to our CISOs. All very good points which we support. I want to talk about 3 cost-effective suggestions that are easily implemented and will have a significant impact on cyber resilience throughout Canada. First, the legislation should be amended to include language that encourages all organizations to voluntarily share cyber threat information and to collaborate with others to build resilience. This can be done with the addition of language in the preamble and 2 small related changes. I'd be happy to provide the committee with some of the proposed text later. The second change is to make membership in a Canadian Cyber Threat Information Sharing Association an allowable expense for government programs. For example, Canada's Industrial and Technological Benefits Policy does not permit membership in an organization as an allowable inclusion. This change would incentivize companies to participate in a sharing and collaboration organization to raise their cyber awareness and resilience on an ongoing way. A small change with significant impact and no cost to the government. Third, this legislation requires only specified organizations to share cyber incident information with their regulators or with the government. We have an opportunity here to create a legal environment that enables all companies, including those specified, to share information beyond what they are required to do by law. The CCTX has Canadian members, Canadian companies, whose American extensions are currently sharing information in the U.S. that they can't share in Canada because they are not protected by legislation. They are concerned about civil liability if they voluntarily share information that could help others to prevent an incident. The objective of C26 is to prevent further cyber incidents. Mandated reporting of incidents is not enough. It will not protect enough organizations quickly enough. By adding protection from civil liability, this legislation could fix that. You could enable companies to share beyond what is strictly necessary to be compliant and improve the cybersecurity and resilience of the economy as a whole in a cost-effective, meaningful way. Without this protection, critical information will continue to be shared with organizations outside of Canada. In creating and supporting the CCTX, Canada's business community continuously demonstrate their willingness and desire to share cyber threat information, to share their expertise and experience, to support Canadian businesses. Help them to do more. Enable them to do more. If enacted as part of this legislation, these three changes will ensure a more secure supply chain for critical infrastructure, which is the focus of this bill, and for all Canadian businesses, large and small. Thank you.
Thank you, Ms. Quaid. Right on time. Mr. Bradley, if you'd like to go next, please.
Oui, merci beaucoup, Monsieur le Président. Oui.
Thank you very much, Chair. I am the CEO of Electricity Canada, formerly known as the Canadian Association for Electricity. Our members are companies which generate, transmit, and distribute electricity in all of the Canadian provinces and territories. My comments today will focus on Part 2 of the bill, the Critical Cyber Systems Protection Act.
Sita, I want to acknowledge the efforts of federal departments in drafting Bill C-26 and the time spent engaging stakeholders over the past 2 years. The problems that the bill is trying to solve are hard ones, with lots of moving pieces, far-reaching implications, and against the backdrop of a constantly evolving threat landscape. Now, while I commend the efforts, I must add my voice to the witnesses you've already heard from who emphasize the importance of getting this legislation right. While we acknowledge the urgency to pass this type of legislation, it is crucial to carefully consider amendments and resist the pressure to rush through the review of the bill. Mandatory security requirements can help strengthen our overall security posture, but the approach taken by C-26 risks having the opposite effect, adding very little security to our sector and redundantly adding additional layers of regulatory requirements. So today, I'll highlight 3 areas where the legislation falls short and requires improvement. So first, the bill must align with existing regulatory frameworks. The electricity sector is unique in that the assets targeted by Bill C-26 are already being regulated by the North American Electric Reliability Corporation, or NERC. This poses a risk of regulatory conflicts, increases the burden on operators, introduces compliance confusion and ambiguity, ultimately impeding the goal of Bill C-26 to enhance the safety of our critical systems. A witness last week recommended that the bill should take a risk-based approach, imposing fewer requirements on those already strong cybersecurity programs. Under this approach, mature organizations could spend more resources on incident prevention instead of compliance activities, and regulators could better focus their time on high-risk operators. Given our sector's strong security posture and the existing NERC standards, we feel that a risk-based approach to Bill C-26 would be a step in the right direction. Another area needing improvement in the bill is its reporting requirements. The reference to the immediate reporting of cyber incidents should be revised. Reporting obligations should not divert critical infrastructure operators from their response and recovery efforts during and post-incident. Reporting requirements should be well-defined, consistent, and have a reporting timeline that is flexible enough to allow the effective use of limited resources during incident response and recovery. And still on the topic of reporting requirements, the goals of the legislation would be better served if it included legal protection for operators. Safe harbor provisions are an important part of promoting information sharing. between industry and government, ensuring the successful implementation of the new reporting requirements, and promoting voluntary information sharing. And the final aspect that I wish to address is the unintended impact of the bill on the existing industry-government collaboration. Imposing mandatory requirements may create a chilling effect on the industry's relationship with government departments and agencies. Without appropriate safeguards, operators will likely receive legal advice to share just enough information to comply with the Act and nothing more. This is counterproductive to the goals of the legislation, but there are a couple of things that you could do to mitigate those risks. First, put clear limits on how the government can use the information collected by way of this Act. Several provisions in the bill would allow for information sharing between a range of persons and entities, and it does not explicitly limit how recipients use the collected information. Second, the Cyber Centre should be carved out from the legislation and exempt from obligations to report information obtained by way of the Act to other entities. Critical infrastructure operators currently enjoy a positive and collaborative relationship with the Cyber Centre. This is grounded in the confidence that the Cyber Centre does not disclose operators' information to regulators, enforcement agencies, or other departments. Protecting the Cyber Centre from information sharing obligations is crucial to maintaining this collaborative relationship. Bien que nombreux autres aspects du projet de loi.
While many other aspects of the bill would also merit attention, I have used all the time available to me at this time this morning, but I would urge you to consult our brief, which includes 14 recommendations on how to improve the bill. Thank you very much.
Thank you, Mr. Bradley. Thank all of you. We're going to move right into the rounds of questions. The first round will be 6 minutes, and we're starting with Mr. Lloyd, please.
Thank you, Mr. Chair, and I want to thank all the witnesses for coming today and for your testimony. And we do take everything you're saying. We're taking notes, and we'll be taking everything you've said under advisement in our consideration of this bill. Going forward, though, we do have another urgent issue that we're facing in this country, and it is the issue of auto thefts. And in the interests of allowing this committee to continue working on C-26, but also to walk and chew gum at the same time and deal with the urgent issue of auto thefts in this country, I plan to be moving my motion that I put on notice at the last committee meeting to discuss. However, given that there have been some discussions with the other parties present, we have come forward with proposed amendments to this motion so that we can program this committee to work simultaneously on C-26 while also working on the very important issue of auto thefts. We know that in 2022, the latest year that auto theft insurance statistics were made available, that $1.2 billion in auto theft claims were made. We know that over 100,000 vehicles were stolen in Canada last year, and this is a growing issue. It's increased year over year, 50% in the provinces of Ontario and Quebec. It's a cross-Canada issue. Alberta's the third highest auto theft issue. This is a very important issue in my riding. And I'm very concerned because we do need education to help people know what tools are available to them to help protect their vehicles from auto theft. But at the same time, if the federal government does not take action to secure our ports and to put these repeat offenders behind bars, I fear that we are going to see an increase in the brazenness of these criminal acts, including violence committed against our citizens, if we don't take action to immediately put a chokehold on this unprecedented flow of Canadians' vehicles out of particularly the Port of Montreal. And I understand, Mr. Chair, that my colleague Larry Brock is on the speaking list and will be next on the speaking list. So, Mr. Chair, in the interests of ensuring that this committee can continue with its very important study on C-26, but also continue and accelerate the study that was already agreed upon by this committee on October 23rd, the motion put forward by our colleagues in the Bloc Québécois, Ms. Michaud, I will cede the floor to my colleague, Mr. Brock, so that he can move the appropriate amendment. Thank you, Mr. Chair.
Mr. Brock.
Thank you, Chair. So the amendment now being proposed reads as follows, that all the words after the word committee in the first paragraph.
Point of order, Mr. Chair. We don't have a motion. There's no motion.
There's a motion on
So you
circulate?
can't move an amendment if there's no motion.
I moved the motion in my
Did-
speech just now.
He
you
moved
read
the
the
motion.
He
The
did
motion has
not.
been circulated to the committee.
He did not.
It was circulated on Wednesday.
You have to,
Can you read the motion,
motion has
Mr.
not been moved.
Yes, Mr. Chair.
Thank you.
Mr. Chair, the original motion as it read that the committee report to the House its acknowledgement that convening a national summit of politicians and insiders to discuss auto theft will not prevent such theft. It also recognizes that preventing auto theft falls squarely under the federal responsibility of the Canada Border Services Agency, the Royal Canadian Mounted Police, Transport Canada, and Public Safety Canada, and recommend to the House that the government, A, immediately reverse changes to Bill C-5, which allows car-stealing criminals to be on house arrest instead of serving jail time, B, strengthen criminal code provisions to ensure that repeat car-stealing criminals remain in jail, and C, provide CBSA and our ports with the necessary resources to prevent stolen cars from leaving the country.
Point of order?
That's my motion, Mr.
Yes.
Chair.
Mr. Chair, I would suggest that this is out of order for two reasons. In terms of what the House has already considered, the House considered yesterday a substantially similar motion. And the Parliament, the House of Commons, decided not to proceed with that motion. As you know, this is a very rare occurrence, Mr. Chair, that ultimately, when a bill is defeated, you can't at the next day suggest to the committee that that bill be considered. In this case, it was an opposition motion, and it was defeated, and now Conservatives are proposing substantially the same motion today at committee. Now, this is something that really doesn't have precedence, Mr. Chair, because it's kind of shameless that when Parliament decides something, that members of the committee would try to come back with what is substantially the same consideration. And it is true that if this was 3 or 4 years from now, you could say, well, things have substantially changed since Parliament considered this issue, so we should have more discussion and debate on the issue. In this case, it was yesterday, it was last night, it was 14 hours ago, where Parliament decided that the motion was inadequate. I certainly moved an amendment, as you'll recall, Mr. Chair, on behalf of the NDP, talking about cracking down on organized crime, cracking down on money laundering, restoring the cuts, the crime prevention programs that the Harper government put in place, and Conservatives rejected that. And so the motion that was offered yesterday in the House was profoundly weak and contained a lot of disinformation. That's why Parliament defeated it. We can't come back the next day and consider substantially the same motion. And as you note, Mr. Chair, the intention would be to recommend to the House. The House made the decision yesterday. The intent of the motion today is to recommend to the House the same thing. There is an issue of repetition that is very clearly in all our procedural manuals, something that is clearly prohibited. You can't keep bringing the same issue up in the same form. Secondly, I would suggest, Mr. Chair, because it recommends to the House, this is trying to do indirectly what is prohibited directly. In other words, trying to use a committee to reconsider something that was considered yesterday by the House of Commons. And
Thank you,
rejected.
Mr. Julian. We're going to suspend for a couple minutes, and I can confer with the clerk. So 2 minutes, please. I take into consideration your comments, Mr. Julian, and after speaking with the clerk, the motion hasn't been put before the committee prior to. I don't have the other motion in front of me right now to compare. So our authority basically is saying that we're going to continue with the motion and allow it to stand at this time.
Mr. Chair, point of order?
Yes,
Challenge that decision, please.
certainly.
Thank you.
Beat me to it, Peter.
Oh, sorry. I think this is ridiculous.
Mr. Julian, do you want to speak to after that? I gave you the opportunity there. You're both up at the same time.
No, I hope we can vote on this and get, our witnesses have given us a tremendous amount of content, and I've got tons of questions, and quite frankly, I'm a little frustrated with all the disruption that the Conservatives have caused over the last few meetings on another subject that then they've decided to drop to try to do this subject. It's just, it's time to start questioning the witnesses.
So we're challenging the chair's ruling. Is a recorded vote?
Mr. Biddle.
No.
Mr. Gay.
No.
Mr. Shifke.
No.
Mr. McKinnon.
No.
No. Mr. Garrison.
No.
Mr. Shipley.
You might have wanted to huddle that one first.
Mr. Shipley.
Yes.
Mr. Lloyd.
Yes.
Mr. Mutz.
Yes.
Mr. Brock.
Yes.
Madame Normandin.
Oui.
Mr. Julian. 6 yeas, 5 nays.
So the chair has been defeated. So we move on?
Yeah.
So we move on now to,
So it would be Mr.
Yeah, Mr. Chair?
yes, please.
I move that we use this time to question the witnesses that have given us such important testimony.
That's the process, yep. So, Mr. Biddle, you're up.
Excellent. Thank you so much. Thank you so much for the witnesses to be here. And it's truly disappointing to see, again, on issues of such importance, to see the Conservatives attempting to hijack this once again when they stand up and pretend to care about security. But to Mr. DeBoer, you mentioned mandatory reporting not only here, but with respect to the executive order in the United States. C-26 requires mandatory reporting for affected sectors when there's a cybersecurity incident. Do you believe this is important, and if so, why?
Thank you for the question through the chair. Yes, it is very important. The executive order, as well as the United States, has also passed a separate law in 2022 requiring it. The reason why it's important is because critical infrastructure entities affect the lives of every single Canadian. We depend on it. Our economy depends on it. This is about our economic security and our national security. And so requiring entities to report those incidents within a reasonable time, and I would suggest aligning it to the United States and the EU, which is 72 hours, would be an important idea. It is fundamental.
Mr. DeBoer, Mr. Bradley raised some concerns about reporting. Do you share those concerns, or?
Absolutely. I share the concerns about there needs to be protection for liability. Absolutely. There also needs to be a due diligence requirement. So in essence, if there were good faith attempts to report or to put in place cyber protections to prevent cybersecurity events, that needs to be respected. We're dealing with highly sophisticated actors. The report that came out yesterday from the U.S. government talked about a Chinese-backed actor that had been in critical infrastructure for 9 months. So these are highly sophisticated. We need to act as a team. And so it will be, I support those amendments as well.
Thank you so much. Ms. Quaid, what safeguards are currently in place to ensure that our critical infrastructure providers are taking action to ensure their systems are sufficient to repel cyber attacks launched by criminal organizations and international adversaries?
So our critical infrastructure sectors are perhaps some of the most sophisticated and have some of the most sophisticated cyber defenses in all of Canada, and are very much aligned with the same sectors in other countries, particularly in the electricity side because of the cross-border side, as well as the finance and telcos. What systems are in place to ensure that? They have regulators that are extraordinarily diligent, would perhaps be a good word, for ensuring that they are aligned and that they have strong defenses in place. So I've really nothing that we can add to what the regulators have suggested. But this regulation is important because, to further say what John was saying, reporting is one of the biggest challenges we have. We don't have good numbers. We don't know how big the problem is in this country because the reporting is different. What is defined as a cyber incident in different reports comes across differently. Who has to report, when they have to report, what is reported. We don't have reliable numbers, and that's part of the problem that we have.
Do you see any, or what risks, if any, do you see if this legislation is not passed or we delay it too long?
Huge. Huge risks. Risks that start with we will lose the faith of our Five Eyes partners. We will lose the faith and trust of the cross-border relationships that we have through NERC and FERC and all of the other ones. And we will also lose resources and revenue.
Thank you so much. Do you think this legislation strikes the right balance in capturing only those firms deemed vital to national security?
So in my remarks, I did comment on the rest of the economy. The truth is the rest of the economy largely supports these 6 sectors. The supply chain, which this legislation does cover, right? The critical infrastructure is now required to be aware of and responsible for the reporting of their supply chain. It does go down the chain. It's a very good start.
Thank you. Mr. Bradley, in order for this regime to be successful, I hope you all agree that designated operators must be confident that the proprietary and commercial sensitive information that they provide to the government is handled appropriately. Would you agree?
Yes.
Yes. The bill currently includes a regime aimed at protecting confidential information. What are your thoughts on this regime found within the bill?
Our concerns are more with respect to treating different entities within the Government of Canada differently when it comes to the protection and the use of information, specifically with respect to the Canadian Cyber Centre. That's where our area of focus is with respect to the use of the information itself.
Ms. Normandin, 6 minutes, please.
Merci beaucoup. Merci à l'ensemble.
Thank you very much, and thank you to all witnesses for your presence here. It's much appreciated. I'd like to begin with questions for Mr. Bradley. You talked about a risk of redundancy in regulations. You mentioned the NERC, but I was wondering whether there are any other levels where there's also a redundancy risk. I know that you have been in conversations with Hydro-Quebec before coming here to make your presentation. Have they also expressed this concern about regulations in Quebec with respect to protection of personal information? Is there any risk of redundancy, not only doubling but tripling of layers of redundancy? Thank you very much.
Excellent question. So in my remarks and in our brief, we're focusing specifically with respect to that interface between the bill and our NERC requirements, which are quite onerous. But the member is absolutely correct. There are other requirements as well that come into play at the different levels of government and also internationally. And so it isn't solely a matter of Bill C-26 coming into conflict with NERC. There are other levels as well. But our particular area of concern where we see the potential for a significantly increased burden is between that lack of alignment between NERC requirements that have been in existence for many years and what is being proposed in C-26.
Merci beaucoup. Ça m'amènerait peut-être.
Thank you very much. This would lead me to a question for Mr. DeBar, because you've also talked about harmonization. I'd like to hear what you have to say about Five Eyes and the incident reporting internationally, because there are various levels of standards. It becomes extremely complex. How would you prioritize harmonization? At what level and why?
So my recommendation would be to align with the United States. As I mentioned earlier, even the Canadian Centre for Cybersecurity has mentioned that an incident affecting critical infrastructure in the United States would affect Canada. Much of our critical infrastructure, whether it be energy, rail, transport, or in some cases telecommunication, crosses borders. We need to align with them. So that would be mine, 72-hour reporting requirement. The other thing is aligning in terms of definition of what is a cyber incident. Currently, the United States is undertaking a study, CISA, to define cyber incident and what is reportable. They have in the United States 52 different regimes of reporting. Imagine an entity dealing with a cybersecurity incident required to report to 10, 15 different entities with different types of cyber incidents. If it's not aligned, this legislation will actually add to the problem, not resolve it.
Merci beaucoup. Une question pour.
Thank you very much. Question for Ms. Quaid. You made a recommendation about opening up the bill so that there could be voluntary collaboration with business and companies, but this speaks to a need for a greater workforce in terms of C26. Is this part of your reflections? Is this an issue or a problem, given that there's a general labor shortage? And I've asked the question of the committee earlier, and I've been told that, yes, this could be an issue. I'd like to know whether this is an issue for you as well, and if you have any possible solutions, if in fact you think that this is a problem.
Thank you for the question. And I'm very glad we can address that here. The labor shortage. So what I suggested was enabling organizations in Canada to report and to speak publicly, to share information about threats and about attacks and incidents without fear of liability. In doing that, we're actually minimizing the labor impact. We're enabling companies to share information so that they don't all have to have specialists doing exactly the same thing. We're enabling companies to share information so that the smaller organizations with less sophisticated teams have an opportunity to learn from the larger organizations to protect themselves in advance of an attack. So what I'm hoping is that by opening up the ability to collaborate, not just with the government, but broadly, without fear of liability, and we are in fact going to have a positive impact without adding to the labor force requirements.
Merci beaucoup. Et justement, sur la question de la
Thank you. And in terms of liability, I'd like to hear from anybody else. My concern is if we eliminate liability, companies who could have a team to ensure that they do the work properly could simply think that they don't have to deal with this, and they may feel that they don't have to respect the C26. Is that a risk if you completely remove the idea of liability?
Think through effective, what my colleague Francis Bradley has talked about is safe harbor legislation, which is what they call it in the U.S. It's what they have in the U.S. Through the effective drafting of something like what they have in the U.S., we can create that fine balance, and that's what we would always aim to do. You never want to remove all responsibility. Certainly removing personal liability from our CISOs who are in very short supply. And one of the speakers last week mentioned that they're leaving at a rate of 75% right now, so we are at risk. But I think with effective drafting of that legislation, we can create balance so that we are not removing all liability, but we are preventing organizations from liability where they are trying to share information for the help of others.
Thank you, Ms. Normanday. Mr. Julian, please, for 6 minutes.
Thank you very much, Mr. Chair. Thanks to our witnesses. You've given us a lot of food for thought. I've got a lot of questions. I hope there is no further disruptions because, quite frankly, my Conservative colleagues haven't asked a single question on C26 to date, and I think that has to change. This is important legislation. I have two questions for all three of you. The first off, Ms. Quaid, you mentioned that further delays would lose the faith of our partners. The government introduced this in June 2022. We're now in February 2024. We're seeing delays and disruption from the official opposition in trying to process this legislation. Beyond losing the faith of our partners, what are the other consequences? We've had previous witnesses saying that Canada is basically becoming increasing a target because we don't have legislation in place. What are the consequences for further delay to all three of you? And my second question is, and this is based on your excellent brief, Mr. Bradley, talking about during the regulatory process doing consultation. To what extent has the industry been consulted by the government in the legislation to date? To what extent was there input so that we get this bill right? And I'll start with Mr. Bradley and then to Mr. DeBoer and Madame Quaid.
Thank you very much. Those are two very, very good questions. On the first question with respect to consequences for delay, and it relates to your second question as well, we've been engaged in discussions about this gap, given that we're a sector that has had mandatory reliability and mandatory critical infrastructure protection standards for a decade and a half. And we have been asking the question, what about those other sectors upon which we rely, the interdependence of the sectors? And some sectors have robust programs. Others, we just don't know, frankly. And so we've been in favor of seeing something broader across different critical infrastructures, those other infrastructures that we depend on. We have a very high level of confidence in the regime that we have because it is mandatory, because it is enforceable. We would like to see something in place, and this has been the conversation that we've been having with the government for a very long time, for other sectors upon which we rely. And so I think C26 does fill that gap. It overlaps, and I did talk about that in my comments. But with respect to consultation, in terms of agencies and departments of the government, we have been talking about this for more than a decade. And so this has been something that we've been consulted on extensively, certainly. But it has been something that has been a gap for quite some time.
Mr. DeBoer?
Yes, so I would echo previous comments. Critical infrastructure is called critical infrastructure because it's essential to our daily lives, the functioning of our economy. So that's critical. But there are other elements to this. If the public believes that government has not acted to protect that critical infrastructure, it's the very trust in our government that could be eroded, and the ability to secure our lives. Affordability is another potential impact. Cyber attacks increase costs. Currently, there are countries in the UK, notably, where insurers will refuse to provide insurance costs to actors who have been attacked by a state-sponsored actor. All those costs are passed on to consumers. So could that also be?
Can I interrupt to ask you, do any of the three of you have figures that you can provide us with in terms of costs or increasing costs because of the lack of action at this point?
I can get back to you on that in terms of certainly increasing insurance premium costs, as well as increasing costs in terms of affordability. So we can get back to the committee, or I can get back to the committee on some of those figures. So there are a tremendous series of consequences that are fundamental to our economy. And you just need to look at, for instance, Ukraine. Their electric grid was shut down. Look at Portsmouth, Florida, where a cyber attack almost poisoned their water system. So you can go to catastrophic ends. In terms of consultation, there has been consultation. Our frustration is that this has moved far too slowly. And it needs to be considered also in conjunction with the critical infrastructure strategy, which has not been updated since 2009. And so what is defined as critical infrastructure needs to be aligned with the critical infrastructure entities outlined in this legislation. And that's all public safety's responsibility.
Ms. Quaid, I'll come back to you because you'll be cut off, unfortunately.
Okay, I'll keep it very short. What are the impacts of this if this legislation doesn't pass? Well, look what happened with Colonial Gas Pipelines. There is at least one death confirmed to be attributed to that. So what's the impact? Death. Let's be simple. If gas doesn't flow, if phone systems don't work, people will not survive. There are also the additional impacts, as Mr. DeBoer was saying, the insurance premiums. It's increasingly difficult to get insurance. My own cyber insurance has gone up exponentially, which means costs associated. I will have to pass that on to customers. The increased cost of doing business, and businesses will go down. Small, mid-sized businesses cannot afford a cyber attack. The cost of remediation is usually in the millions of dollars. So those costs have to go somewhere.
Thank
and in
you,
terms of collaboration...
Thank you, Mr. Julian, Ms. Quaid. Thank you.
Okay.
I'm sure you'll have another opportunity. That's round one. We're moving into round two now. Mr. Motz, you're up for 5 minutes.
Thank you very much, Chair, and thank you for our witnesses for being here. I know it's been stated, the rush to get this through. We've waited since June of 2022, and it was put on the books, and we're still doing the little dance. I've heard witnesses say so far that we need to ask ourselves what's more important, rushing this bill through even though it's faulty, or trying to at least fix it so that it's workable to get some things right moving forward. And that's something that I'll ask all of you to respond to. But I want to also include in that response, there's also been concern by witnesses that the bill is vague in many areas and the regulations are going to try and fix the gaps. And the recommendation has been that there should be more definitions, there should be other language that provides clarity that is in the bill rather than in the regulations, and provide clarity to those, because regulations could take another couple of years to finish, right? And that's the concern that we all have. So I'd just like to get your thoughts on those, and I'll start with you, Ms. Quaid.
I would say that there's a balancing act, that the bill, it is important. The bill is important. There's absolutely no question. And there's also no question it needs some modification. But I think with a little effort, enough of the bill can be fixed effectively to make it good legislation that can then be amended, or not amended, but fine-tuned in the regulation. So I think with focus and effort, I think we can get it right and get it now.
Mr. DeBoer?
Fully agree. We need to get this moving now. It's never going to be a perfect bill, but we need to make the adjustments we suggested, which is to clarify what is considered a cyber incident, align it with the U.S.'s definition, reporting timelines as well. Clarity is really essential in times of crisis, and so we need to do that. But those are easy fixes. Those are things that we can probably fix within a few modifications. So I would fill those gaps, get this passed, and continue to work on other elements.
Thank you. Mr. Bradley?
Thank you very much, Mr. Chair. This is an excellent question. Do we rush the bill through, or do we amend it to make it right? My response is let's do both. Let's rush this bill through, but rush it through while taking into consideration the 14 recommendations that we've made, and to make the amendments that respond to those 14 recommendations.
Thank you. I'm going to stay with you, Mr. Bradley. You indicated in your written brief that, and I quote, "The bill risks adding very little security to our sector," end of quote. I was a bit troubled to read that, and certainly our electrical grid and the reliability of electricity is perhaps some of our most critical infrastructure components. You state then further that the bill, and I quote again, "should provide tools and protocols to add to the safety of Canada's infrastructure sector." What are those specific protocols and tools that you mentioned, if you haven't already mentioned them in your opening?
Thank you very much. With respect to the bill not significantly adding to the security, and in fact potentially diverting attention, it is not an issue with the bill itself. It's that the bar has already been raised higher than what's in Bill C-26 as a result of the mandatory standards that our sector is already subject through the North American Electric Reliability Standards regime. So that bar has been set already higher. So what has been put in C26 does not improve upon that, but it detracts because it diverts attention to a separate and second parallel reporting structure as opposed to using those resources to work on response.
All right, thank you. For the time I have left, the Canadian Chamber of Commerce has indicated that a patchwork is a disadvantage to business if we don't get this right. And I think the other obstacle that I noticed, Mr. DeBoer, in the BlackBerry produced a white paper back in 2022, and the biggest obstacle that you saw that was mentioned briefly already is the lack of skilled people, the lack of resources, skilled resources to deal with this at the business level, critical infrastructure business level first, then maybe at a larger threat environment. Do you see that changing since 2022 when that was written?
Thank you. I also co-chair with the Canadian Chamber, the Cyber Right Now Council.
Mr. Motz, I'm going to have to, sorry to interrupt, but it's a hard stop because we're running out of time and I want to be able to make sure that everybody has an opportunity. Mr. Gahir, please.
Great. Thank you, Chair, and thank you to all the witnesses for making time for this committee. My questions are largely for Mr. Bradley from Electricity Canada. How many organizations are represented under your organization?
There are 40 companies that are principal members of the association, from the largest electricity companies in the country like Hydro-Quebec down to the municipal utilities in Ontario.
How many of those organizations currently have a cybersecurity program in place?
All of them.
All of them. I would assume there's a little bit of variability in the different programs at different organizations?
Absolutely. Depending upon the size of the organization, of course, there would be variability. But all of those that are involved in the bulk power system are covered by the North American Electric Reliability Corporation's mandatory cyber security standards. And as a result, those companies have very robust and consistent cybersecurity programs.
Okay. So what are the consequences of a successful cyber attack against a critical infrastructure operator in the energy sector?
Well, as has been mentioned already by this panel, not in Canada, but in other jurisdictions. We've seen a loss of pipeline in the United States, and in Ukraine in 2015, we saw for the first time a successful cyber attack anywhere in the world resulting in loss of power to customers. So that's not something that's happened here, but those are the potential consequences of cyber attacks.
Sure. So obviously this is a very vital sector. I think everyone here understands that. I think that's why I was a little bit surprised in your opening testimony when you sort of spoke against the mandatory requirements in this bill, when he spoke against the immediate reporting. When I listened to the testimony by Ms. Quaid, she indicates that reporting varies, that is not reliable. So I just wanted to get your take on that.
When a cyber event is occurring, do we want our people working on paperwork for regulators, or do we want them at that moment working on securing the systems? And so we want to, first and foremost, have people working on securing the systems, and then look at what are the reporting requirements. So it's a question of easing the reporting and the regulatory burden, number one. But number two, my concern is about duplication here, because we already do have reporting requirements. And so we're talking about creating now a second reporting regime as well.
So you had mentioned that this other regime is actually a higher standard. So wouldn't it be easier to meet this lower standard contained within this bill?
It would be, except that if the definitions are going to be different, it means a separate and different reporting structure, different definitions. In fact, not entirely joking, I had said a number of years ago when the government was beginning to move along this path that they potentially could look at the NERC cybersecurity standards and look at replicating those for other sectors in the Canadian critical infrastructure sectors. That would have made our life certainly easier if we looked at the existing regime that we had and looked at applying it to other sectors.
But I guess you would agree that whether it's because of this regime or another regime, that mandatory reporting requirements are important, that, that information collection is important.
Absolutely.
Yeah. Okay. Thank you, Chair.
Absolutely. Yep.
Thank you.
Okay, Ms. Normandet, please, for 2.5 minutes.
Merci beaucoup. Une question.
Thank you very much. I have a question for all of our witnesses, and feel free to respond. There's a sort of balance in this bill between what's in the bill and the regulatory aspect. I know that there are a lot of definitions which will flow from regulations and sanctions and who is targeted, etc. Could you comment on this? We know that this is cyber world is very quickly evolving world. Maybe it would be good to have flexibility in having a lot of regulations, but maybe this could be hard on small business. Are we up to date? Or are we keeping up with what's going on? What's the balance between the two? I'd like to hear you on that, please.
Go ahead, John. You want to start?
Sure. I think there still needs to be clarity in terms of, as we mentioned, some of the definition issues. But the equilibrium in terms of, for instance, sanctioning and the fines, et cetera, there needs to be some level of consequence for negligence, for failure to implement certain cybersecurity, a baseline cybersecurity standard. And there also needs to be encouragement for large critical infrastructure entities to ensure that their supply chain is secure. And that means working closely with their small and medium-sized businesses. The other thing I would add is that in the United States, the U.S. government has created a grant program to enable critical infrastructure entities to put in place certain baseline cybersecurity requirements. So that could be another suggestions. But finally, the last thing I would mention in terms of the right equilibrium, this law pushes a prevention-first approach. And we know in medicine, prevention is oftentimes better than the cure. Let's get people to invest up front.
So if I can pick up on what Mr. DeBoer was saying in terms of incentives for those small, medium organizations, if we enable the larger organizations to share openly and truthfully and fully with the small, medium organizations what they're seeing and what they are doing, and support them so that they don't get hit with the same attack, the prevention is better than the cure. That will help. Another approach we could take is to incentivize businesses, not necessarily ones covered by this legislation because that's a separate piece, but their supply chain. If we could incentivize the supply chain to reach a level of cyber maturity through tax incentives, through insurance breaks if they have certifications.
Great. Thank you, Mr. Normandet. Last speaker, please, or last questions, Mr. Julian, please.
Thank you, Mr. Chair, and I'd like to congratulate Mr. Motz on asking the first question on C26 for the Conservatives a month into the study. I'd like to go back to you, Ms. Quaid. The issue of consultation, also the question of whether or not we're increasingly a target because of the lack of action and delay around important legislation. My third question is just to come back to your recommendation around expenses for joining, if I got this correctly, the Canadian Cyber Threat Exchange. To what extent that would be a cost? You said no cost, but I'm sure there would be. Have you evaluated what that would be, and what are the advantages from that? So 3 questions for 2 minutes.
All right, I'll take the last question first, and that is the reference to joining the CCTX. In fact, I said a Canadian cyber collaboration organization, not necessarily ours, although that would be wonderful. When I said there's no cost to the government for that, because it would be part of the ITB program. So any of the organizations, any of the companies that are working through the IT or are impacted by the ITB program could join a threat sharing association so that they can be more aware of what's going on in the cyber ecosystem, what the attack vectors are likely to be, and remediation and resiliency solutions. So that's the first one. No cost to the government. There is a cost for us, but it's nominal for small businesses, really small. The other question you had earlier, I believe, was on collaboration. On consultation. So there was certainly an opportunity for consultation several years ago. And we did participate in that with our members as well, because we reached out to them, so it became a trickle down. But it would be nice to see something like C26 run in concert with the National Cyber Strategy, which was also, the consultation was several years ago and is now 2 years behind. So I see that coming down the pipeline. And the third question...
was, is it true, as some witnesses have pointed out, that increasingly Canada is a target because we haven't put in place the measures to protect against cybersecurity?
That may be harsh. Canada is increasingly a target because we do pay ransom. So there are organizations, there are countries that they don't attack intentionally because they don't pay ransom. Canada generally does pay ransom, or Canadian organizations.
Thank you, Ms. Quaid, Mr. Julian. That's your time. Thank you so much to the witnesses for being here today on a very important topic.
Chair?
We're going to suspend.
Can I just ask the witnesses if there's anything that's further that came up today from the questions being asked you couldn't get a fulsome answer to? Could you please provide it to the committee for our deliberations and report? Thank you.
Thank you. So we're going to suspend for 5 minutes and get ready for another round of witnesses. So thank you so much for being here. I'd like to welcome our second panel of witnesses. By video conference also, Canada Energy Regulator, Chris Rowan, Executive Vice President Regulatory, is also online. Christopher Finley, Director, Emergency Management and Security. In person, we have Canadian Radio, Television and Telecommunications Commission, Stephen Haroun, Chief Compliance and Enforcement Officer, Anthony McIntyre, General Counsel and Deputy Executive Director, Legal Services, and Leila Wright, Executive Director, Telecommunications. So up to 5 minutes we'll be giving for opening remarks, after which we will proceed with rounds of questions. Welcome to all of you. I now invite Mr. Lowen to make an opening statement, please. Is he on there?
Good morning. Bonjour. My name is Chris Lowen. I'm the Executive Vice President Regulatory at the Canada Energy Regulator. I'm joined today by Mr. Chris Finley, Director of Emergency Management and Security. Thank you for inviting the Canada Energy Regulator to appear before the committee today to discuss Bill C-26. We join you today from Calgary, and I would like to take this opportunity to acknowledge the traditional territories of the people of the Treaty 7 region of southern Alberta. J'aimerais d'abord vous présenter une
I'd first like to give you an overview of the regulator's mandate. CER works to regulate infrastructure so as to ensure the safe and efficient flow of energy throughout the country and elsewhere in the world as well. CER regulates pipelines, electricity transmission lines, the development of energy resources, and the trading of energy on behalf of the Canadian population. We do this so as to protect the public and the environment while promoting market efficiency.
Safety is at the core of our work. We regulate to prevent harm in all forms and understand that this includes the cybersecurity threats that Bill C-26 is seeking to address. The CER takes the matter of cybersecurity threats to Canada's energy supply seriously. The CER oversees roughly 71,000 kilometers of the oil and gas pipelines in Canada. We regulate pipelines that cross provincial boundaries or the Canada-U.S. border. CER-regulated pipeline companies are required to have proactive measures in place to protect this critical infrastructure from cybersecurity threats. Regulated companies must have a security management program that anticipates, prevents, manages, mitigates conditions that could adversely affect people, property, or the environment. In addition to the physical threats to infrastructure, companies must consider cybersecurity threats in their security management program and implement appropriate mitigations based on the results of a security risk assessment process. These requirements are laid out in the Canadian Standards Association's Z 246.1 standard, which is included in the CER Act onshore pipelines regulations by reference. Cybersecurity measures must reflect the criticality of cyber assets, as well as the results of regular assessments of threats, vulnerabilities, and overall security risk. The regulation of electricity generation, transmission, and distribution rests primarily within the jurisdiction of provinces and territories. However, the CER regulates approximately 1,500 kilometers of international power lines. The Canadian public rightfully expects us to hold the pipeline and international power line companies we regulate accountable for the safe operation of CER-regulated energy infrastructure. The CER is well positioned to administer the obligations of Bill C-26, in particular those that apply to companies we regulate, and given these obligations align with those already found in the Canadian Energy Regulator Act. For example, the bill provides the CER with the ability to issue orders and to take necessary enforcement actions to bring a company back into compliance, so that critical cyber systems are protected. La Régie utilise déjà des outils.
The CER is already using similar tools. For example, the CER publishes notices of non-compliance, inspection orders, and financial administrative sanctions, as needed, to bring companies back into compliance and to ensure their safe operations. The CER also checks whether companies respect the requirements. This is done through inspections, audits, compliance meetings, and emergency intervention exercises.
CER uses integrated government approach. We work with federal, territorial, provincial, and international agencies, as well as regulated industry, to ensure that proactive measures are taken to protect federally regulated energy infrastructure from cyber-related risks or attacks. Thank you very much for the opportunity to speak with you today about this important issue, and we look forward to your questions.
Thank you, Mr. Lowe. And Ms. Wright, please.
Morning, and thank you for inviting us to speak with you this morning. Before I begin my remarks, I'd like to acknowledge that we are gathered on the traditional unceded territory of the Anishinaabe people. My name is Layla Wright, and I am the Executive Director of Telecommunications at the CRTC. I'm joined today by my colleague Stephen Haroon, Chief Compliance and Enforcement Officer, as well as Anthony McIntyre, General Counsel. Le CRTC est un tribunal.
The CRTC is an independent quasi-judicial tribunal that operates at arm's length from the government. We hold public hearings on telecommunications and broadcasting matters. And we make decisions based on the public record.
Telecommunications industry, our work focuses on increasing competition for internet and cell phone services. We do this by promoting greater choice and affordability for Canadians, encouraging investment in reliable and high-quality networks, and improving access to telecommunications services in Indigenous, rural, and remote communities. We also have a team that helps protect Canadians from unwanted emails, texts, and online scams. Le CRTC joue un rôle modeste dans.
The CRTC plays a small part in the federal government's effort to protect the security of Canada's telecommunications system.
That contribute to this effort include the Communications Security Establishment, the Canadian Security Intelligence Service, Innovation, Science and Economic Development Canada, the Canadian Security Telecommunications Advisory Committee, and many others. The CRTC does not have a role to play within the proposed Critical Cyber Systems Protection Act. Additionally, many of the proposed amendments to the Telecommunications Act establish new authorities exclusively for the Governor and Council and Minister of Industry, and do not modify the CRTC's regulatory mandate under the Act. Toutefois, quelques modifications.
However, there are a few changes that would be relevant to the CRTC's work. There are three in particular that I would like to acknowledge.
The proposed amendment to Section 7 of the Telecommunications Act would add a new policy objective focused on promoting the security of Canadian telecommunications systems. As with other policy objectives set out in the Act, this addition would allow the CRTC to expressly consider how our decisions could further this new objective. Second, the addition of Section 15.6 would facilitate information sharing between a broad group of securities-focused government departments and agencies and the CRTC, and this would be for the purpose of ensuring compliance with orders and regulations made by the Governor and Council and the Minister. Et troisièmement, l'article 40.
And third, Section 47 would require the CRTC to take into account any orders or regulations made by the Governor and Council or by the Minister in our decision-making.
Adopt Bill C-26, the CRTC will be ready to implement amendments made to the Telecommunications Act that affect our work. Thank you again for inviting us to speak today, and we look forward to your questions.
Thank you, Ms. Wright. We're going to move right into questions now, and Mr. Shipley is up first for 6 minutes, please.
Thank you, Chair, and thank you for all the witnesses for being here today. In the first hour of witnesses this morning, we heard a shocking number from Mr. DeBoer that 5.2 million cyber attacks were stopped. That number just shocks me. I'd like to know through Mr. Lowen, as the regulatory board for your energy sector, how many of those are you seeing in your area that you're responsible for?
Well, thank you very much for the question. You know, that's, I would have to say that that's one of the reasons why reporting is going to be very important with respect to the proposed legislation. Currently, right now, we rely on reporting coming from companies that provides us, I would say, an understanding of the magnitude, but not the actual specific numbers of cyber threats or cyber attacks that are occurring with respect to our companies. The regulated industry is targeted by a number of threats from domestic and non-state state actors that I would say vary from password theft, document theft, all the way up to ransomware and other types of malware. I might just turn to my colleague, Mr. Chris Finley, and he might be able to provide you with a better sense of this, the volume.
Yes, thank you for the question. Well, to date, the Canada Energy Regulator has no evidence of any cyber security incidents that have suffered by regulated companies that have affected their the operation of a pipeline. In other words, their operational technology network. Admittedly, we also have had no reported incidents that have caused a cybersecurity event. There are a series of reportable incidents in our regulation, so there has been nothing reported to date. And in terms of our regulated industry, of course, they are always under threat, and many of those attacks are below the bar. We certainly wouldn't hear about those, and there is voluntary reporting currently to the Canadian Cyber Centre. Thank you.
Thank you. I think somewhere in there was a little bit of good news for us that, as I said, that number at the beginning, 5.2 million, and hearing yours obviously considerably less than that will help us sleep a little better at night. But how will 26 change the way you do business overall? Will it help your members and help yourselves? What's the main implication if and when this is passed, how it's going to change?
Well, thank you very much. The legislation is the proposed legislation is well aligned with what the CER's oversight mandate. We already have a fairly robust regulatory framework in place that requires companies to identify and anticipate threats, risks to their systems and processes and operations, and have programs in place that prevent and mitigate those events. We also have in place inspection officers, the ability to issue non-compliances, inspection officer orders, and where necessary, administrative monetary penalties. So you can see that the elements of the proposed legislation do closely mirror what we currently have in place. And then in addition to that, it enhances reporting and information sharing, which I think can only lead to a much stronger oversight of cyber threats within our industry.
Thank you for that, and I'll turn to our witnesses at the CRTC this morning, probably Ms. Wright, who started off. There's been concerns at the fact that in instances where an order in council or ministerial order or regulation were to override a decision from the CRTC, there may not be a public notice or notice of decision. Do you agree that this process should be more transparent?
Thanks very much for the question. As the CRTC's role is to implement the legislation that is adopted by Parliament, our role is not to comment on proposed legislation that is before Parliament, and so unfortunately I'm not able to respond to your question.
Thank you. Would you support provisions that require the government to table an annual report that would include the number of times government orders or regulations have prevailed over CRTC decisions?
I would respectfully say that that would be a question for ISED.
I'm sorry, I can't hear you.
That would be a question that should be posed to our colleagues at ISED.
Okay. Thank you, Chair.
Thank you. Thank you, Mr. Shipley. So we're moving on to Mr. Scheifke, please, for 6 minutes.
Thank you very much, Mr. Chair. And I'd like to thank our witnesses for being here in person and virtually. I'll begin my line of questioning with Mr. Loewen. Mr. Loewen, in layman's terms, for Canadians that are interested and affected by this topic, what would the consequences be of a successful cyber attack against critical infrastructure operator in the energy sector?
Thank you for that question. The consequences could potentially vary greatly and depend on the nature of the attack, obviously. In the Cyber Center's assessment, the main threat to Canada's energy sector is from financially motivated cyber criminals, primarily using things like ransomware, as I had noted earlier. And those attacks are most typically affect information technology networks, although it is possible for them to target operational technology. The ransomware on an IT network will cost a regulated company money, potentially in paying the ransom, but certainly in lost time and in recovering their infrastructure. Ransomware on an OT network or operational technology network, such as a SCADA system, while rare, could be far more disruptive to a pipeline's operations, although this would be unlikely to create unsafe operating conditions. And as my colleague had noted earlier, we have no evidence and we have heard no reports of any such breach of an operational technology system on CER regulated or in CER regulated industry.
So just following up on that, given the interconnectedness of the energy sector in Canada and our largest trading partner and ally, the United States, how important is C26? How important is it for Canada to strengthen our cybersecurity protection?
Well, I would respond in saying that the energy sector is targeted by nation-state cyber espionage activities that don't recognize borders. These are primarily a threat to intellectual property, research, business plans. And because the energy sector is strategically important, critical infrastructure and is border, as you had noted, it is also likely a target for adversarial nation states to sabotage, if possible, operational technology. And the impact on that would be significant.
Is there anything, one of the main focuses here in this committee is to improve on this bill, look for things that are not included perhaps on this bill that we can include that would strengthen C26. Is there anything that our trading partner, the United States, our ally, the United States, is doing that we are not doing that perhaps is not included in C26 that you believe should be included?
We were not the lead on this particular legislation, but we did provide advice. In my view, it's very well aligned already with what we have in place at the CER. I might just turn it over to my colleague, Mr. Chris Finlay, as he is more familiar with some of the activities that are taking place in the United States.
Mr. Finlay?
Yes, thank you. So we do work closely with Transportation Security Administration as well as PHMSA, the Pipeline Hazardous Materials Safety Administration, but primarily within Canada, very closely with the Communications Security Establishment and the Cyber Center to make sure we're in alignment internally. And we believe, as my colleague said, that the robustness of our regulatory environment currently is solid. However, we do see a real benefit in the the mandatory reporting requirements as set out in Section 17 to 19, which we think will be very beneficial because we can take that information and implement that across our pipeline network and make it safer. Thank you.
Thank you both. I'll now turn my questioning to Ms. Wright. Ms. Wright, thank you for being here. A priority for all of us here, regardless of political party, is to protect the privacy of Canadians. And some witnesses have warned that this bill may result in the government accessing, collecting, and misusing personal information, including personal cell phone information. In your reading of this bill, and based on your experience and your position, do you see that happening?
Again, unfortunately, I'm not able to respond to that question. Our role is really to implement the provisions that are that touch upon the CRTC's work, and I've outlined those provisions. They're quite narrow, and so I'm not able to respond to that question.
Would you be able to comment on how C-26 will intersect the Privacy Act, and is there anything in the bill that affect the applicability of the Act?
Unfortunately, I'm not able to respond to that question.
Okay. I guess I'll just ask you one last question before my time is up. Is there anything that is not in C-26, Ms. Wright, that you would like to see in C-26 that perhaps would provide greater support for the work that you're doing?
Again, our role is to implement the legislation that is adopted by Parliament rather than to comment on proposed legislation that is before the committee.
Okay. Thank you, Ms. Wright. That's all, Mr. Chair. Thank you.
Yeah, Mr. Julian, for 6 minutes, please.
Et, Monsieur le Président, je vais poser une question.
Chair, I'll be asking a question for Madame Normandin. I would like you to be a little bit flexible in terms of the number of minutes that I have. I will ask her question, and then I'll ask my question, if that's okay. The question for Ms. Wright deals with recommendations that we've received from Citizen Lab, which proposed easing up requirements for smaller SMEs that are in telecommunications. Do you think it's important for a regulatory framework for C-26 in terms of the impact that it would have on smaller telecommunications entities, and to have that taken into consideration, to have some sort of flexibility in the implementation so as to avoid that they have problems implementing these components of C-26?
Thank you for the question, and I apologize if my response is frustrating to the committee. Our role is to implement legislation that is adopted by Parliament. When it comes to the proposed legislation before the committee today, we can speak to the proposed amendments to the Telecommunications Act that touch on the CRTC's work, and also can speak to how similar provisions are currently applied by the CRTC. However, I'm not able to respond to your question.
Okay, thank you. I'd like to go to Mr. Lowe and Mr. Finley. Mr. Finley, you said when asked by Mr. Shipley about the number of incidences that nothing has been reported to date, but there may have been incidences reported to the Cyber Center. Can you explain to us, number one, whether you'd be aware of incidences that were reported to the Cyber Center, whether that is part of the situational report that you receive? And I find it a bit surprising, quite frankly, that there's nothing reported to date. I'm assuming that means above a certain threshold of incident, if that's possible. If you could clarify your remarks on that, I think that would be helpful because as Mr. Shipley mentioned, BlackBerry just testified to over 5 million attempted cyber attacks in the last 90 days that they've been able to head off. It seemed to me that the energy sector would be a target of these bad players.
Yes, certainly I can clarify my remarks. The energy sector is a target. There's no question. It's a the question in answering the question. Generally, there is no reporting requirement on cybersecurity incidents currently to the Canada Energy Regulator. So what we do is we work closely with our regulated companies in the Cyber Center, and we encourage voluntary reporting between our company and the Cyber Center, and they create non-disclosure agreements. So they collect information, and they will share that information out to industries in a form that is, without disclosing details of what those incidents and attacks were. So that's, I guess, what this bill would do, would strengthen that mandatory reporting and allow us to get access to that information more freely than we have now, certainly.
So currently you have no access to that information, and would it be fair to say currently there's no sharing of best practices? So if there is an attempt on an energy company, the information wouldn't be available on how to stop that attack to other companies in the energy sector. Would that be an accurate depiction of how the situation is today?
I think the way the situation is now is, in terms of reporting to the CER, there is no cybersecurity mandatory reporting unless it meets a definition in the onshore pipeline regulation for another type of incident, such as operation beyond design or something more significant. But that information is reported voluntarily into the cyber center, and again, they produce reports. There may be a question for the cyber center. They do produce threat risk reports, and they distribute that within our industry and more broadly, so that certainly companies do have information or access to it to take measures to put the right mitigation in place.
Okay, I appreciate your honesty on this. It's disturbing to me, because would that not mean, for example, the shutdown of the Colonial Gas Pipeline that has been referenced by other witnesses, that that information about how to stop that type of attack would not necessarily be available to Canadian energy companies and not available to the energy regulator? Or is it that we're getting information about attacks outside our frontiers, outside Canada, but within Canada, attacks are not necessarily shared in any way to ensure that energy companies in this case are actually able to bulwark themselves against a repetition of that attack?
I certainly think that it could be, through the bill, more structured, more formalized, and then those mechanisms would be in place to share that information officially. As you can appreciate, some of this information comes with some cautions in terms of how widely it can be shared due to confidentiality. But again, we do have relationships informally, both with the Cyber Center, with other federal departments and agencies to get that information. We do, through our compliance verification activities, look at a company's programs and systems and make sure that they're doing everything that they can, that they are connected with the Cyber Center and getting the latest threat and risk briefings and taking the measures that they can take.
The chair has been very generous. I just have one further question then, specifically on Colonial Gas. Were you given access to the information about that attack and how to prevent an attack of that nature in the future?
Yeah, that's a pipeline that was in the United States. So not officially, certainly through various working relationships that we have with our staff and different departments, we've learned about that incident, but I'm not prepared to comment on kind of the details of that.
Thank you, Mr. Finlay. Thank you, Mr. Julian. We're moving into the second round. We're pretty good timing here, so Mr. Lloyd, you're up for 5 minutes.
Thank you, Mr. Chair, and thank you for the witnesses for coming. My questions are going to be focused on the Canadian Energy Regulator. I think there's been a little bit of confusion with this bill, and some people who are watching this might believe that if we don't pass this bill, or if it gets delayed, companies won't be spending on cybersecurity. But it's pretty clear that companies are spending a lot on cybersecurity. For example, major integrated oil company Cenovus has announced in its 2024 budget that they're spending over $100 million on cybersecurity. So it certainly seems that many companies across many sectors are taking this issue very seriously. However, we just had witnesses in the last panel, I believe from Electricity Canada, that were concerned about this bill because they believe that it might not necessarily lead to a massive increase in spending on incidents reporting and incidents prevention, but it will massively increase the amount of money that companies have to spend just to comply with the legislation. I'm wondering if you can comment. Do you foresee under this legislation the compliance costs for companies increasing significantly?
Well, as I had mentioned and thank you very much for the question. As I mentioned in the opening remarks, the proposed legislation is very well aligned with what we already have in place. At the CER, we already have a robust regulatory framework that involves inspection officers, inspection officer orders, the issuing of non-compliances, use of administrative monetary penalties, the conduct of inspections, and companies are already well familiar with the need to have cybersecurity programs in place in order to detect and prevent the threats. So in terms of the overall impact on the CER's regulated industry in terms of cost, I think some of that detail needs to be determined through the development of regulations, which have not been yet developed or proposed. And the other part of it is I would point to the fact that what the bill is proposing is in large part a formalization of the powers and the oversight framework that we have in place, but extending it further so that it formalizes, as Mr. Finley noted earlier, the reporting relationships, the information gathering, and the sharing of that on the government side.
And so if I'm clear from what you're saying is that this, for at least for CER regulated industries, many of the practices for cybersecurity that are put in this bill are already in practice. And just to summarize what you said, this bill is really just formalizing something that already exists. And I think it wouldn't be a stretch to say that across a number of other sectors, including the CRTC, that there already do exist these practices and in some cases regulations to ensure cybersecurity. So I'm concerned that the government is looking at formalizing this, but also increasing their powers when Canadians should be somewhat assured that at least in your industry, there already is significant spending by the private sector on this. Electricity Canada also said that there was a concern that this formalized legislation, this new legislation, could create a chilling effect, where rather than having a very good relationship between yourself, for example, and the designated operators underneath you, where you have a very open dialogue about cybersecurity and what needs to be done, that there could be a chilling effect where lawyers are advising companies only to give the government the information that's necessary under the Act. Can you comment on that chilling effect? Do you agree with Electricity Canada that there's a bit of a threat there that this chilling effect could occur?
Well, thanks again for the follow-up. And to clarify, what we see already with respect to our relationships with industry is a network of a patchwork, I would say, of voluntary interrelationships with respect to reporting, usage, and gathering of information. When I use the word formalizing, what I'm saying is that is a beneficial aspect of this bill. And I think industry is well prepared to implement the aspects of the bill associated with that. It will strengthen our ability as a government in order to prevent and assist our regulated industry in detecting and mitigating any potential cyber threats in the future. With respect to the comments of Electricity Canada and the chilling effect, our experience with respect to pipeline industry and threats to the environment, safety and other areas has been that reporting gives and clarity around reporting, which would be, I expect, something that will be developed in the regulations, sets a not so much a floor, but it does help with the expectations around that.
Thank you, Mr. Lowen. Thank you. Your time's up.
Yeah.
Thank you. Mr. McKinnon, please.
Thank you, Chair. My questions are for the energy regulator. You mentioned reporting requirements and so forth and good data. This intersects information we heard from previous witnesses around the need for consistent and concise definitions so that the data can be captured across the different industries and the different situations and have meaning. Would you have comments on that?
Well, I think anytime that you can bring consistency and clarity to a sector, it's a benefit, and it's a benefit for everyone. At the CER, we have a long history in implementing our regulatory framework with respect to the onshore pipeline regulations, other regulations, and usage of things to help with clarity around reporting requirements, such as event reporting guidelines, and other directives and guidance materials that are welcomed by industry and help them understand the expectations of the regulator. And I think what that does is it overall strengthens the protections in an industry. And I do see that as an aspect of this particular requirements in this bill. The regulations, as I noted earlier, are still to be developed. And should the bill pass, I'm looking forward to working with the lead departments and agencies on this bill to provide advice.
Do you feel that these definitions are best dealt with in regulation, or should they be incorporated into the bill itself?
Well, as a not being the lead on the development of this, I think I would prefer to say that regulations are an area where it does provide the ability for some flexibility in terms of development going forward, and any amendments that might be required in the future, rather than having to amend legislation.
There was also discussion earlier about the United States undertaking an effort to provide a consistent set of definitions across their various 52-some regimes, I believe. Is that something that would benefit us? And is that something that we are perhaps participating in any way?
I don't know if I can speak to the specific situation that you're describing, but what I would suggest is that the coordination and the cooperation that we have with our counterparts in the United States, such as Pipeline Hazardous Materials and Safety Administration, which regulates pipelines, has been very good. Consistency of definitions is definitely something that is welcomed by industry. Again, consistency and a coherent regulatory framework is I would say a welcome development whenever it can be put in place.
Okay. So when we talk about cyber incidents, it seems very generic, very abstract. I wonder if you could give us some clarity on the kinds of incidents we're dealing with. What sort of attacks are we looking at? And who are the bad actors here? Is it some hacker in his mom's basement, or is it international, whatever, right? Could you give us some insight on that?
Yeah, I'll say a few words, and then I'll turn it over to my colleague, Mr. Finley, to color that in a little bit. It ranges. It goes from the person in the basement to a nation-state actor. There is, and I think earlier when we were discussing incidents and reporting, one of the distinctions that the CER draws is the difference between an attack on an information technology network, that is the network that provides your email, stores your documents and passwords, and then the operational technology network, which is the systems that are used to operate pipeline valves and other systems. To date, there has been no successful attack that we're aware of in Canada on the in the CER's regulated industry on a operational network. Within an internet, your information technology networks, the ones with passwords, et cetera, yes, those have happened quite frequently. Mr. Finley, did you want to maybe color that in a little bit?
Yes, as my colleague mentioned, the majority of attacks are on IT networks, ransomware, typically by cyber criminals, nation states. We don't have all of that information at our fingertips. But that is the kind of information that we work closely with the Canadian Center for Cybersecurity, who does have that information.
Mr. Finley, thank you.
They do collect that information.
Thank you, Mr. Finley. Mr. McKinnon, thank you so much. Mr. Julian, please, for 2.5 minutes.
Thanks very much, Mr. Chair. To Ms. Wright, the CRTC, do you track in any way incidences of cybersecurity breaches among telecommunications companies and other companies that are under your jurisdiction?
Well, the CRTC does not have a role with respect to cybersecurity. Perhaps I will give the question to my colleague Stephen Haroon, who can speak about some of the enforcement work that we do in this space.
Yeah, thanks for the question. To your specific question, no, I think the Canadian Center for Cybersecurity is your best witness on that information, as my energy regulator colleague mentioned.
But so you are unaware, you are not told by any of the companies that are under your jurisdiction, any of the entities, that there's been a cybersecurity breach?
We work very closely with our colleagues at ISED to regulate in this space, and we can undertake to get back to you with a response.
Yeah, I think that would be helpful, because we've been stunned by some of the massive numbers of figures of cybersecurity breaches or attempts. And this morning we heard from BlackBerry over 5 million in the last 90 days. So it would seem to me both, and it's similar to the energy sector, telecommunications sector, these are vital sectors, and it would seem to me self-evident that there would be attacks and attempts. What I hear is that at this point there's no gathering of that information, and I think it's of some concern. So if you have any information at all that you can provide to committee, that would be helpful. Can I ask to what extent the CRTC was consulted on this bill prior to it being tabled? Was there any consultation at all? Did the government reach out to you, given your regulatory role?
Perhaps I can direct that question to my colleague, Mr. McIntyre.
Thank you for the question. We were consulted prior to the tabling of the bill. Given the fact that our role under the amendments is very limited, we were only sort of consulted on the few provisions that would apply to us. So we weren't sort of involved in the sort of policy discussions sort of beyond what applies to us in the legislation.
And is what you see in the legislation reflective of the kind of feedback that the CRTC provided?
Don't know that I'm in a position to comment on that. But.
Thank you, Mr. McIntyre. Mr. Julian, please. What we're going to do now is we get 2.5 minutes each for the final 2 questions. You up? Mr. Motz, please. 2.5 minutes.
Thank you very much, Chair. I'll focus my questions to the CRTC. Last year, the Auditor General reported that the CRTC was not doing enough to track the affordability of internet and cellular services, particularly in rural and remote areas. Now, has the CRTC undertaken any sort of analysis of the impacts of C26 as written, how that would have impact on the prices that Canadians pay for internet and cellular services?
Not to my knowledge.
So you don't know, okay, interesting. Do you think it will have an impact on the prices of internet and cellular service?
It's difficult for me to respond to that question without additional data and information. What I can say is that the CRTC is working very hard to promote choice and affordability for Canadians across the country, including in Indigenous, rural, and remote communities.
Okay, I would encourage you to consider the question and to see whether there is an impact on what the question asked. We also know that C11 and C18 gave sweeping new powers to the CRTC. We've heard from witnesses that C26 as written also grants too much power, mainly ministerial power. And how do you recommend amending the Act to give Canadians the confidence that there will be proper oversight without overreach, and that there's transparency and accountability that's balanced?
unfortunately not in a position to comment on the legislation that is before the committee. Our role is to implement legislation that is passed by Parliament.
Okay, I'm done then, Chair.
Thank you, Mr. Mott. So we're going to move on to Mr. Garrettson, please, for the final. No. Okay. Is there anybody interested in taking the final spot? Mr. McKinnon, please, for 2.5 minutes.
So I do understand that you're a quasi-judicial body, and that limits what you can respond to here. But we're here to study C-26 to make it better, so that when it is delivered out into the world, it does its job. So is there anything that you guys can offer us that will help us do that?
What I can do is comment on the proposed amendments to the Telecommunications Act that touch on the CRTC's work. One of those proposed amendments is to allow the CRTC and other securities-focused government departments and agencies to share information in particular circumstances. We, in other areas, have the ability to share information among departments and agencies. And my colleague Stephen Haroon can speak to some of the ways that we have used that ability.
Thank you for the question. And to build on Ms. Wright's comment is, as one of my roles is the compliance and enforcement with Canada's anti-spam legislation. In that legislation, there is very prescribed information sharing with my partners at the Office of the Privacy Commissioner and the Competition Bureau. And we can share information as it relates to CASL and as it relates to our specific roles in enforcing that legislation. That has proven to be very effective.
Thank you.
Thank you. That concludes our meeting today, and
Sorry, can I ask
yes.
Just quickly, I just been wondering, the Minister of Public Safety was scheduled to arrive for us for a 2-hour discussion in regards to victims' rights. That's passed for quite some time now. Do we have any idea when the Minister will be coming for those 2 hours? That wasn't agreed to motion quite a while ago.
Thank you. We'll follow up. Mr. Shipley, we're still waiting for an answer.
Thank you, as we are.
Thank you to the witnesses again. And is the committee in agreement to adjourn the meeting? Is the committee in agreement to adjourn the meeting? Yes. I want to be clear on this one. Thank you.